Hi, happy July 4th, everyone. Over the holiday weekend, Amber Heard's legal team has filed a new motion to throw out the jury verdict in the Johnny Depp versus Amber Heard defamation trial. And they've made 5 arguments as to why the jury's verdict is improper and violates due process and deprives her of a fair trial. So, the 5 reasons that they say the jury verdict should be thrown out is first, that the jury's verdict is inconsistent. They say that there's an inconsistent verdict because on the one hand, the jury found that Amber Heard had defamed Johnny Depp through false allegations of AB that were published in the op-ed Washington Times article. But on the other hand, they found that Johnny Depp's lawyer, Mr. Waldman, made defamatory statements against Ms. Heard in the Daily Mail article that he published in April of 2020. The second reason that they say the jury verdict should be thrown out is that there was a problem with one of the jurors who appears in the jury registry as being much older than the actual juror that took part in the trial, because this gentleman was supposed to have been born in 1945, but actually was born in 1970. They are making the claim that this could have impacted the trial and the verdict. And they're saying that potentially this was a plant or this was somebody who came forward who may have been partial to Johnny Depp, but they haven't actually provided any evidence of any prejudice or shown that that's the case. Third, they're saying that there was improper evidence of defamation by implication because the statements didn't directly refer to Johnny Depp, and so they were privileged under the First Amendment, similar to this type of a commentary video or criticism from a news media outlet, where there's a First Amendment privilege to speak about matters of public concern and to have a free and open, robust debate in the public forum about issues that we all care about. And that includes the ability to make inferences and innuendo against people that have put themselves out in the public eye, such as celebrities. The problem with that argument, though, is that the statements in the op-ed article for the Washington Times were about Ms. Heard's own experiences, and they were directly related to her prior relationship and the allegations of AB that arose in 2016. On a similar vein, their fourth argument is that the judge improperly allowed evidence of damages dating all the way back to 2016 and that spanned the time period after 2018, despite rulings that the court had that circumscribed the allowable evidence, because the damages that Johnny Depp was allowed to claim were only those that occurred between 2016 and 2018, and that was a compromise that the judge made in how the evidence would be presented, because she did not allow prejudicial testimony relating to this UK trial, which had a different outcome, and so the jury shouldn't have been allowed to hear other evidence, Amber claims, of damages that went beyond the time period that the judge permitted evidence to be provided for of damages. So basically in the trial, Johnny Depp was trying to prove that he was damaged after this article came out in 2018, and that impacted his career immediately, and then continued to impact his career so that he couldn't get work and lost work for things like Pirates of the Caribbean 6 and the role with Fantastic Beasts in the Harry Potter series. And because of those reasons, he was entitled to millions of dollars of damages. But Amber's team is saying, well, no, the damages that were argued at closing in Camille Vasquez's riveting closing arguments that she asked the jury to award were those going back all the way to the false statements that were made in 2016 and up through the present, because they were claiming that he had lost, quote, no less than everything, end quote, and that he'd been living with this lie hanging over his head and impacting his career for a total of 6 years. Lastly, the fifth grounds on which they bring this motion is that Amber Heard's legal team is saying that retweeting an article is also the equivalent of a First Amendment privileged activity, and that one does not endorse or speak to the truth of something merely because they republish it. And under the rules and precedent in the state of Virginia, where there's a single publication rule, you can't simply be found to be liable for defamation for retweeting something that was published by somebody else. In other words, the Washington Post published this article, and even though she was the opinion writer, she's saying that the republication of it was not her publication. And this is getting very meta because obviously she wrote the article. So there's a lot of reasons why that final ground, though interesting, probably doesn't hold a lot of water. Starting with the end here, is this going to go anywhere? Is this whole trial verdict going to be overturned and thrown out? And are we going to be sitting through, take two of the Johnny Depp versus Amber Heard trial for another 6 weeks? Well, I don't know. I can't say that for certain, but I would venture a guess that this is the probability of success here is very, very, very low, and that the judge is going to uphold the jury verdict. Judges do their best to do a trial once, and they do everything that they can to preside over that trial in a fair and even-handed manner, and will only disturb a jury verdict when it's clearly erroneous and in the most egregious of circumstances, where clear prejudice is shown and due process rights are violated in such a substantial manner that the violation goes to the very heart of the case and the outcome of the trial. I could get into the specific legal requirements, but suffice it to say that generally it's an uphill battle to get a jury verdict thrown out. So what is Amber Heard's legal team really doing here? Basically what they're doing is they're setting the stage for their appeal, and they're getting these arguments out into the public in front of the judge, forcing the judge to make a ruling and put her opinions down on record as to these matters so that it will strengthen their ability to appeal later. So what we're going to do is we're going to go through the actual motion a little bit, and we're going to go through the verdict form as to this primary argument of the inconsistent verdicts. So we're going to start with that first argument, which is probably the meatiest, and go from there. So here you have the motion, and this is Amber Heard's post-trial motion to set aside the jury's verdict and to call for the investigation of improper juror service, penned by none other than Elaine Brennenhoft and Mr. Benjamin Rottenborn. The arguments here are laid out in the table of contents, and they start with the damages. Obviously, that is a thorn in their side, but then go on to their primary argument about the inconsistent verdicts, the First Amendment argument of defamation by implication, which this is a very important argument for Amber from a public relations standpoint, and this might be the one thing that comes out of this case for posterity, aside from the public nature of it and how much legal commentary there's been and how it's colored a lot of people's views of how these types of hard-fought legal battles should go. This issue is interesting because what are the contours of what a public figure, what kind of scrutiny that there can be of a public figure by virtue of them putting themselves out into the public eye. This defamation by implication argument is these 2 points here, and then down a little further is this related argument of defamation by innuendo, and we'll get into what those both are, but they're basically the same. And then the last argument is about this juror number 15 issue, which is also pretty juicy, but once again, if this was a situation where there was no prejudice, then it won't hold a lot of water. The Amber Heard legal team did a really good job of putting forth a proper legal motion. They cited some really important cases like New York Times v. Sullivan. That's a famous First Amendment case that we've all had to read in law school. And Palin v. New York Times Co., a more recent First Amendment case. They brought up some of these cases, Perlman v. Vox Media. They relied heavily on some Fourth Circuit cases that have to do with the requirements of defamation in Virginia. And they've relied on a lot of, well-known legal precedent in these areas, as well as laying out their claims under the Virginia Code. Unfortunately, I don't think there's a lot of there. These are well-constructed legal arguments, but they don't, what you'll see that the jury looked at the evidence and rendered a verdict in a manner that makes sense, using one's common sense, and that is in keeping with the due process requirements under the law, and that indicates a fair trial was had, and the jury just came down in a manner that Amber Heard's team doesn't like, but doesn't show that there was some violation of process that would warrant redoing this entire trial. So here, Amber Heard's team says the jury's dueling verdicts are inconsistent and irreconcilable. The findings of defamation against Ms. Heard with a $2 million award is inconsistent with the finding of defamation against Mr. Depp with a $15 million award. In face of these inconsistent verdicts, the judgment should be set aside and a new trial ordered. So that's a strong statement. So let's unpack that a little bit and dig in to see if they're right, or as I'm going to recommend to you, that they're not right. So what are we talking about here? So there was one counterclaim in this trial. If you remember the very dramatic moment when the jury verdict was read, I was in my office with one of my law clerks, my office manager, when it happened. We were watching it live on a stream. It seemed, as the jury read off its verdicts for Johnny Depp, that he was vindicated, and it was this moment of, high drama that was followed by a little bit of a weird moment when they found that Amber Heard also made out one of her counterclaims, and that was counterclaim number 2. And I've got it here for you on the screen, and we're going to talk about it for a little bit. The jury found, that defamation occurred as to this statement. So here's the counterclaim. As to this statement appearing in the April 27, 2020 online edition of the Daily Mail. And this is from Mr. Waldman, an attorney that's speaking on behalf of Mr. Depp. Quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempts didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine and roughed the place up, got their story straight under the direction of a lawyer and publicist, and then placed a second call to 911. Do you find that Miss Heard has proven all the elements of defamation? And these are the elements. First, Mr. Waldman, while acting as an agent for Depp, made or published the statement. So on this point, right, this was published in the Daily Mail, so he made the statement to the press. That the statement was about Miss Heard. Don't think there's any problem with that, right? Because it basically names her right here. So that one seems pretty clear. The statement was seen by someone other than Miss Heard. Well, we know it was published and it was out there in the public eye, and that the statement was false. And then finally, if you answered yes to each of these subparts of question 2A, answer the following question. Do you find that Ms. Heard was proven by clear and convincing evidence that the statement by Mr. Waldman was made with actual malice? Okay. So was the statement false, and was it made with actual malice? Let's go back up to the statement. I think what happened here, in order for there to be inconsistent verdicts, there has to be no rational basis under which a juror could conclude both things. So the jury found, and we'll go back up to Mr. Depp's claims, that the op-ed statements in the Washington Post were false. So this is speculation, but the jury may have determined that Amber lied about the AB of a physical and sexual nature, that she embellished the facts of what really happened in the actual events that transpired, and that she invented some incidents that never happened. But they still believed that there was an argument that prompted this 911 call on the night in question. And they found that Waldman's statements that this was an ambush and a hoax and a setup were overselling the truth of what really happened and minimizing Johnny Depp's involvement. If you remember the trial, and you were watching it closely like I was, Amber brought out her best friend, Raquel Pennington, and she testified to Johnny Depp's behavior and about what he was doing on the night in question, that he was acting in an aggressive manner, that he was yelling and running back and forth into different apartments, and that she personally witnessed this behavior. And then her husband also confirmed that, and indicated at one point that he was, that he believed that Mr. Depp had done something wrong that would make out AB, and that for that reason they were trying to protect Amber. But maybe one of the most compelling instances of testimony was there was a woman whose name escapes me right now, who was also friends with Amber and Rocky, that had known Amber for a long time, and she didn't testify to much, but she happened to be there visiting when this incident happened, and she talked about how Johnny came in to the penthouse where she was at, told everybody to get out, and had his security team with him, and that she was scared, and she talked about how terrified she was. So it stands to reason that the jury could have heard all of this testimony, the testimony about where they believed that Amber was either making up or lying about AB or embellishing and adding components of physical, sexual nature to the arguments that happened in the relationship. But they also could believe that he got out of hand on this particular night to a degree where, getting law enforcement involved might have been warranted. And that therefore, when he minimized this to his agent, Mr. Waldman, and let him publish the statement that it was an ambush and a hoax, that this was the same type of embellishment that Amber had been engaging in, the same type of overselling, and that this was a false statement that was put out maliciously to make her look bad in the press. So Amber's team has made a lot out of this particular verdict existing for her, and is trying to say you can't have this verdict and also have the other verdict because they're talking about the same things, but they're really not. And that's why I think that the judge is going to rule that the verdict was consistent, not inconsistent. If you've ever been involved in a jury trial as an attorney, or if you've been a juror, or if you've watched one on TV, the part that you don't get to see is when the juror actually, is back in the jury room and the jury deliberates and what goes on. It's been, televised and depicted in various TV series and movies, but it's not something that we get to see when a trial unfolds. I'll tell you what happens. The jury, they go back and they've got this charge that they've got to come up with a unanimous verdict. And people don't agree on everything, right? So it's natural for juries to have a compromise verdict, or to compromise their opinions and their positions about what they feel the evidence shows in order to get to unanimity. And that's what they're supposed to do. They make their arguments, and the courts are very reluctant to upset a jury verdict, and there's such a high bar that it's very rare that a judge is going to do that if there is a rational basis for the jury verdict that did come down. So in a case like this, Amber's team has to show that no reasonable jury could find both things to be true, and they're not going to be able to do that, because I just told you just one way, my speculation, that the jury could have been debating this and they could have come to this conclusion that both of these things were true. And there's always going to be horse trading and negotiation in the jury room. And I have had the privilege of doing jury trials, and I've had the opportunity to work as a law clerk for a judge that did a number of jury trials, and to see them when working at a government agency. And I've been privy to some of the jury questions, jury deliberation, and this is exactly the kind of thing that happens, that a real jury does, is they look at the evidence and they render an opinion and a judgment on the case based on how they view the evidence as a whole, with all of the different views taken into account, and they come to a compromise on their verdict. Sometimes you don't know about it because you don't have these types of competing claims. All right, so the inconsistent verdict argument here, they go on to go into it a little deeper, but it's ultimately not going to go anywhere, in my opinion. So let's move on to the damages argument next. Here is the argument that they're making about damages. They're saying that in the closing arguments, Camille Vasquez asked for damages going back to May 27, 2016, the date of the TRO, all the way up through the present, and from beginning of their opening statements all the way through their closings, they always argued that basically she took no less than everything, and 6 years of Johnny Depp's life were stolen from him and his reputation, and that he should be compensated for the loss for all that time, not just the lost opportunities that followed the op-ed. But the only things that were on the verdict sheet here are the statements. Let's go back and look at it. The only thing that Johnny Depp was allowed to get damages for here are the statements: I spoke up against sexual AB and faced our culture's wrath. That has to change. Then 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. I had the rare vantage point of seeing in real time how institutions protect men accused of AB. So then they ask the amount of compensatory damages if Johnny Depp proved 1, 2, and 3, which he proved 1 and 2, but they didn't, I believe, rule on the last one as being defamatory towards Johnny. So the verdict sheet does tell them to award compensatory and punitive damages only for the statements, but it doesn't break down by statement. So it's not perfect, but it doesn't, there isn't anything in there that would show that they didn't award the damages properly, or that they looked at evidence from the past or the future that they weren't supposed to. But the evidence that was brought into the trial had to cover that time period, because in order for Johnny Depp's team to prove that the statements were false, the first 2 statements there, that AB occurred, they had to go back to the actual incidents. And there was testimony from many witnesses, including experts, about the different allegations that Amber Heard made of AB and whether or not they happened. There was also testimony about the lack of evidence and calling into question some of the evidence, like the pictures of Amber that would show her on the days when she claimed to be hurt. There was evidence about makeup. There was evidence about all these things. And that had to be brought in so that they could make a credibility determination about who was telling the truth. And they could look at the evidence and weigh it and see if they thought that it supported her claims. So, you have evidence that comes in for different purposes, right? You have this evidence that about whether or not the allegations that Amber Heard made in the op-ed were true or defamatory, which was it. And then you have the damages that stemmed from the defamatory statements she actually made, if the jury in fact found, as they did, that they were defamatory. So it's splitting hairs here to say there's no evidence here that Johnny Depp, suffered damages after the op-ed, and they point to the fact that there wasn't a contract in place for Pirates of the Caribbean 6. But this is a franchise role where he's been in 5 movies, and there's nothing to suggest, or I don't think anybody reasonably would think that they would go with somebody else, that Disney was going to pick somebody else and not let him reprise the role if he wanted to. And they also say that since there was no contract in place, his damages should have been cut off in 2020. This is because the judge didn't let evidence about the UK trial from 2024 to come in, so Johnny Depp's team wasn't allowed to bring in damages of things that happened after 2020, but they brought in evidence from Disney corporate executives saying that they had decided not to go with Johnny at the time of the op-ed article. So I think that this, while nuanced, this argument doesn't really work for Amber Heard's team, because the evidence actually didn't go back before the op-ed article. That was actually the evidence that the statements were false, and it didn't go forward past the UK trial date, which was the confines the judge put on the evidence of damages, but rather talked about decisions that were being made at the time that impacted his career. So I think that Johnny Depp's team did a good job of making the arguments as broadly as they could, but they stayed within their lane. Here's Mr. Depp is not entitled to damages for conduct prior to the op-ed. And it says here, about 6 years ago, Ms. Heard made some quite heinous and disturbing, brought these certain criminal acts against me that were not based on any species of truth. Again, he's got to say that the original allegations of AB were not truthful to prove his claims, as you saw in the verdict sheet. And then he says about the TRO in 2016, the news of this, her accusations, had sort of permeated the industry and then made its way through media and social media. It became quite global, let's say fact, if you will. I felt it my responsibility to stand up, not only for myself in that instance, but for my children, and he goes on. So they're saying by him testifying about 2016 and how public these allegations became and the impact on his career, which he attributes to them. I mean, I think one of the Disney executives straight out said that this is why they made their decisions. And then this statement here, I've spoken up for what I've been carrying on my back reluctantly for 6 years. All of that, they say, is evidence of his damages, but in reality it's evidence that he's claiming that the allegations were false from the outset, that were then incorporated and adopted in the op-ed article in the Washington Post. Okay, so that argument about the damages, once again, is, I think, that the weakest argument, because I think they're just basically splitting hairs, and they're playing with the way the evidence was used, and there's no legs to that argument. They're way out ahead of their skis on that. Okay, now, going back a moment to the inconsistent verdicts, this part here, they're saying, if the jury found that she lied, then they couldn't have found that Waldman also lied because it was the same material. But as I pointed out, it's not the same issue. It's whether so the statements that she made were that AB occurred, Johnny Depp did it to me, and I'm a survivor. And they found that the detail, at least, of the AB being physical and sexual was clearly false, and that it was overstated for effect. It was overstated because they wanted to attack. She was trying to attack Johnny, and she was trying to be malicious about it and to prop herself up and for her own personal gain at his expense. But the other statement by Mr. Waldman, similarly, was propped up and overstated and embellished to attack Amber in the same type of fashion. And so they had this compromise verdict where they thought there was some wrongdoing on both sides, and that makes perfect sense. Their last statement is kind of a throwaway, which kind of tells you everything you need to know. they say here on this point, at a minimum, the jury's finding in favor of Ms. Heard necessarily precludes a finding of actual malice by her with respect to Depp's claims. So again, they're missing the forest for the trees here. The jury didn't, or at least my speculation, my view of one rational reason why the jury had this verdict that was of a compromised nature is that they didn't believe Amber Heard's allegations, but they also didn't believe that on the night 911 was called, that nothing happened and it was a complete hoax or set up or premeditated. They felt that incident happened, but not the way that she said, and that there was enough of a basis for her friends, at least, who were impugned in the article along with her as being involved in some kind of conspiracy, that they didn't buy that conspiracy type of a story. And I would tend to agree with them from hearing the testimony that there was certainly some points when Amber Heard's witnesses testified where it was not believable, but a lot of what they said was. A lot of the things that they said, including Io and even Raquel and her husband, there appeared to be concern over the argument that was taking place, sufficient that, the call to 911 wasn't some kind of hoax or setup, but was something that at least was made out of actual concern. And I don't think Amber was the one that actually called. So to impugn her as being, she might have, got her friends riled up, and she might have been overly dramatic, potentially. I don't know. Or justifiably concerned. But whichever it was, the jury was not, they didn't see enough evidence that that was a made-up event. All right, so now we get to the third argument, which is defamation by implication. And what this is all about here is that public figures are open to scrutiny in the public eye. They put themselves on the public stage. Celebrities are open to criticism, both from critics and from fans and from commentators and from those that follow their work, by the very nature of that work. And their personal lives also become the subject of some public concern. So it says here, the plaintiffs were public figures and the subject matter touched on matters of public concern. The publicity attending the subject matter, the press had freedom to discuss. Several jurisdictions have held defamation by implication is not recognized as a viable cause of action when the statements at issue concern public figures or matters of public concern. And so, what is Amber Heard's team talking about here? What they're getting at, and they're citing to some powerhouse cases, some legal cases, is that you're allowed to criticize President Biden. Okay, you're allowed to talk about Will Smith's slap at the Oscars with Chris Rock, and you can give your opinion about those things, and you can comment on them, and that's within your First Amendment rights. That's one of the things that makes our country unique and special, is our ability to have this free public debate. And I'm glad that she brought up this First Amendment thing, because right now in our country there's a lot going on surrounding First Amendment rights, and it's something that we need to talk about is what the extent of those rights are. But this case, Strata v. Connecticut newspaper, the statement here is, just as the goal of a free and active press protects false statements of fact regarding public figures published without malice, so too must the law protect truthful facts that may give rise to false innuendo or inferences. Second, as a result of their fame, public figures enjoy a platform that allows them to reach a broad audience when expressing their viewpoints. Public officials and public figures usually enjoy significantly greater access to the channels of communication and hence have a more realistic opportunity to counteract false statements than private individuals normally do. With this benefit comes the risk of closer public scrutiny than might otherwise be the case. And what they're saying is that it's a higher standard, right, for a public figure. You have to actually go after them with malice and tell something that you know to be false. Just reading between the lines, looking at inferences and innuendo, and making statements can't be considered defamation, because that would just chill free speech. It wouldn't allow us to talk about these things, because we don't have enough information to sometimes know what's true and what's false. In fact, most of the time we don't know the real true story. So we can only comment and opine and speculate. And we shouldn't be held accountable or dragged into court if our speculation or our inferences or commentary isn't directly on all fours with what actually happened. So what Amber's trying to do is say that she was doing an opinion piece in the Washington Post, and she's saying I was giving my opinion about these matters of concern to women, and therefore I have this license to go beyond what's truthful and to make inferences. But and she points to this landmark case, New York Times v. Sullivan, which we all read in law school, which says debate on public issues should be uninhibited, robust, and wide open. And now she's taking the imperator of the power of that concept in that case, that seminal case, and trying to glom her attacks on her ex-husband on there. But it falls flat because she is not a commentator. She was a participant who had direct personal knowledge of what happened in their relationship and was using it to give herself a greater platform and to attack Johnny Depp, if the statements are untrue, as the jury found, unjustifiably, in a way that she knew would harm him, and she did it anyway. And so I think the judge will easily find that this wasn't a First Amendment matter, and that the jury found the statements to be untrue because it was based on her own personal experience, and they heard about her personal experience and found that the statements that she made weren't supported by the evidence they heard. And so for that reason, I think they're going to easily knock out this First Amendment article or argument, and that is not going to be something, although it's very interesting, that's going to go up on the appeal, or isn't going to get anywhere on the appeal, I would imagine. She now makes another interesting argument that's sort of packed in with the same argument, that she didn't write the headline. The Washington Post did. So if I didn't write the headline, then I can't be held accountable for the headline, which said, I spoke up against AB of sexual nature and faced our culture's wrath. That has to change. And she's saying that was what they put up as the headline. I didn't write that. So that's one of the statements. It's defamatory and I shouldn't be held accountable. But it's really, that headline adopted everything that was in the actual article. And so a reasonable jury could conclude that those were misheard statements, although the exact words may not have been written by her, and that she adopted them, and that she gave her permission to the publication. All right, guys, so that's a lot, and we're going down now to the last two arguments that Amber Heard's team makes. Out of the ones that we just discussed, we had the inconsistent verdict, damages, and the First Amendment. The inconsistent verdict was their best argument, in my opinion. The First Amendment argument is very interesting to talk about, but I don't think has much weight. And the damages argument, I think, clearly is just off. So now she's going to claim that, just like she didn't write the headline of the article, in argument number 4, she says that she didn't republish the article because Virginia follows a single publication rule under this case Fairfax. And that someone, and so this is interesting because it is on this First Amendment idea, right? A mere hyperlink without more cannot constitute republication. Tweeting a link does not constitute republication, even if the tweet includes a mere reference to the article. Tweets which merely refer to the article are not republication. Though a link and reference may bring readers' attention to the existence of an article, they do not republish the article. Stated differently, republication occurs when the speaker has affirmatively reiterated the statement. Okay. What are we talking about here? If you retweet something about that somebody said about the Will Smith Chris Rock slap, right? You're not adopting the statement they're making or saying that it's true, because you are not affirmatively reiterating the statement. You're commenting. It's like meta, or it's like derivative. You're commenting on the comment, so you don't adopt it and it doesn't become yours. You're in an editorial critical role, like a newspaper reporter, and not in the role of somebody making a statement against someone. And so you have protections. It's only the person that initially makes the statement. Everybody else that runs with it can't be held accountable if that first person lied. However, these are misheard statements that she's calling attention to and republicizing to her Twitter audience. These are her loyal fans. These are people that are interested in her, and she is reiterating the statement. She is putting it out there to put her message out before the public eye. And so if it turns out that she's doing that and the statement is based on a falsity, it stands to reason that she's responsible. And she's responsible, and it is malicious because she knows that her following is going to be prejudiced against Mr. Depp on a false basis, if, as the jury found, if those statements are not based on truth. So that wraps up those arguments, and we get down to the fifth and final argument, which is this juror issue. And I agree with Amber Heard's team here, although they don't go into a lot of detail, that the judge should conduct an investigation and find out why the juror was, something like 20, 30 years younger than the person that was supposed to be there testifying, or supposed to be there serving as a juror. It says the court should investigate whether juror 15 properly served on the jury. I agree. The judge is probably going to send some written questions to this juror, ask for some identification, ask why they came to the courthouse if they're the wrong person. But as long as they're in the same jurisdiction, living in the same household, one commentator said that they would have to be showing a prejudice. And I agree, there has to be showing a prejudice if this was an honest mistake and it was somebody who would have been qualified to serve as a juror in that jurisdiction. There shouldn't be any kind of problem. The public information demonstrates that the actual juror was born in 1970, but the juror that was called was born in 1945. Virginia Code 801-353.1 says, at the time of assembly for the purpose of juror selection, the identity of each member of the jury veneer shall be verified as provided in this section. And that this is a due process, complying and adhering to that is a matter of due process and is necessary to ensure due process, even if not mandated by statute, and that it supplies grounds for a mistrial or assignable error on appeal. The Virginia Code does not contemplate jury service by someone not on the veneer for good reason. I mean, that's obvious. So she doesn't have any evidence of prejudice, so she's asking the judge to look into it to see if the judge comes up with anything, and that makes sense. But this is a Hail Mary. There'd need to be showing a prejudice that would have deprived Amber Heard of a fair trial and would have violated her due process rights. And I don't think that anything is going to come to light that's going to meet that standard. So, despite Elaine Bredehoft and Mr. Benjamin Rottenborn doing a good job with their legal brief and putting their arguments together the best they can, I think that they're going to not have enough to even remotely come close to overturning the jury's verdict, but we will see. I could be wrong. And I think Mr. Chu and Ms. Vasquez will file a brief that hits many of the reasons that I just gave in reviewing this on this video, which was something I had a lot of fun doing. And what I would ask is, this is a very interesting issue for us lawyers and anybody that's interested in trials. So what I'd really love to see is for those of you who watched this video all the way through and were interested in it, to comment on what you thought of my analysis as a practicing lawyer who does trials, and what you thought of the 5 arguments that Amber Heard's team came up with and their legal work here. And comment on how you think the judge is going to decide this and whether or not the judge should reverse the jury's verdict and order a new trial for any one of these reasons, or whether you think this is just a flailing attempt by Amber Heard's team. Any comments that you have would be appreciated. I'd love to start dialogue. I hope to do more of these videos where I go through contemporary legal issues that are going on right now and give you a real lawyer's take on them for educational purposes and in order to give my audience some further context for these really interesting legal issues that are happening out there today. I hope everyone has a great July 4th, and take some time to put some comments down so we can further discuss these issues. Thank you so much.